Hello everyone. Today we are going to discuss about employee monitoring laws. Yes, the compliance framework business must follow in 2026. So we will discuss in detail about the laws which are required to monitor. Yes. Are you ready? Let's deep dive into the session. In March 2020, when offices emptied overnight, employee monitoring adoption tripled within 60 days. But 2023, 60% large employers were using some form of monitoring, double the pre-pandemic rate. But here is the problem nobody talks about. British Airways faced penalties for monitoring violations. Barclays came under fire from UK regulator. Teleperformance faced international scrutiny for invasive webcam surveillance. These are not small companies making rookie mistakes. These are sophisticated organizations with legal teams. So, what going wrong? Forrester research found that 78% of the business implement monitoring tools without consulting legal counsel first. Nearly 4 out of 5 organizations treat disease as a purely technical decision, missing that monitoring creates legal obligations that vary dramatically by location and industry. Over the next 12 minutes, we are walking through a practical compliance framework covering geography, industry and its requirements, and consent architecture, data protection, and implementation best practices. So you can deploy workforce monitoring that protects your organization while giving you the visibility you need. In March 2020, when offices emptied overnight, something unprecedented happened in the business of the world. Employee monitoring platforms saw adoption rates triple within 60 days. By 2023, Gartner research confirmed that we were seeing across the market 60% of large employers now use some form of employee monitoring. That is a double the 30% we saw before the pandemic. But there is the problem nobody talks about in the sales demos. The regulatory landscape did not evolve at the same speed in the technology adoption. Let me give you 3 examples from just the last 18 months. British Airways faced significant penalties for implementing monitoring practices that violated UK employment law. Barclays came under the fire from the UK Finance Conduct Authority for using the monitoring software that tracked employee activity in a ways that regulators deemed invasive and poorly disclosed. And Teleperformance, one of the world's largest call center operators, faced international security when their monitoring practices in Colombia included webcam surveillance that employee claimed violated their privacy rights in a home environment. These are not small companies making rookie mistakes. These are sophisticated organizations with legal departments, HR teams, and compliance officers. So, what is going wrong? Forrester published a research last year that should concern every business leader in this space. 78% of businesses implemented monitoring tools without consulting the legal counsel before deployment. Think about that for a moment. Nearly 4 out of 5 organizations treat employees monitoring as a purely technical or HR decision. They evaluate features, compare prices, run a pilot with one team, and then roll out to company-wide. What they are missing is that monitoring is not just a productive tool anymore. It's a legal instrument that creates the data, establishes records, and can be used as an evidence in employment disputes, discrimination cases, and regulatory audits. For organizations using the timestamp specifically, this matters because our platform captures detailed workforce data, application usage, website visits, ideal time calculations, productivity scores, attendance patterns, and activity timelines. The data has enormous operational value, but it also creates a compliance obligations that vary dramatically based on where your employee work, what industry you are operating, and how you have structured consent from disclosure. Here is the bottom line. Monitoring without compliance doesn't just create a legal risk. It creates liability that completely outweighs any productivity gains you might achieve. Unlike the European Union's unified GDPR framework, the US has no comprehensive federal law governing employees monitoring. Instead, you are dealing with a patchwork of state laws, industry specific regulations, and evolving case laws that changes depending on where employees physically work. Here is the federal baseline. The Electronic Communication Privacy Act, or ECPA from 1986, yes, written before the internet was we know it, allows employees to monitor electronic communications if they have legitimate business purpose. And since the employer owns the system, that's usually satisfied. But that's just the floor, not the ceiling. State laws and layers of complexity that can trip up even sophisticated compliance teams. Over the next 10 minutes, we are going to walk you through a practical compliance framework built around 5 pillars: geography, industry specific requirements, consent architecture, data protection, obligations, and implementations based on practices. By the end of this video, you will know exactly how to deploy TimeChamp in a way that protects your organization while still giving you the best workforce visibility you need. Let's start with the most common: geography. Now let's talk about the United States, where the compliance landscape is frankly a mess. This is not theoretical. In 2022, a Florida-based logistics company faced a class action lawsuit after implementing the screenshots monitoring without explicit employee consent. The case centered on captured Microsoft Teams conversation. The settlement cost them over the $300,000 plus legal fees. And the landscape keeps shifting. New York currently has proposed legislation, Senate Bill S7623, that would require employers using automated decision-making systems for productivity evaluation to provide algorithms transparency. That means explaining how your productivity scores are calculated, what data inputs are used, and how employees can challenge inaccurate assessments. Similar bills are moving through committees in Massachusetts and Vermont. Imagine you're a 150-person software development company with remote employees in Connecticut, California, and Texas. You want to deploy TimeChamp across your entire workforce to track application usage, active hours, and productivity patterns. For your Connecticut employees, you must provide written notice before monitoring begins. That notice needs to specify what's being monitored and why. The California employees, you need that same notice plus CPRA, complaint disclosure about data retention and usage. And you need to disable any feature that might capture communication content without two-party consent. For Texas employees, the requirements are lighter, but you still need a documented legitimate business purpose and a reasonable scope. This means your TimeChamp deployment can't be one size fits all. You need location-based configurations. Screenshot features enables in Texas, are restricted and disabled in California. Communication tracking requires explicit consent forms in two-party states. Data retention policies must align with the strict state where you have employees. So, what's the safe harbor approach that works across most US jurisdictions? In TimeChamp, this is translate to configuring monitoring policies by location, maintaining audit logs of consent, and using features like productivity, scoring, and ideal time analysis while disabling the invasive screenshots or keystroke capture in high-risk jurisdictions. That's in the US landscape, complex, fragmented, and constantly evolving. Now let's look how Europe approaches this very differently. If you thought the US patchwork was complicated, let me introduce you to the European Union, where employee monitoring is not just regulated. It's fundamentally under GDPR, monitoring is not a workplace practice. It's data processing, and that distinction changes everything. Every screenshot, every keystroke log, every website visit you track is personal data under GDPR, which means you need a legal basis under Article 6 before you even install the software. There are 6 legal bases available, but here is what matters for monitoring employees' consent doesn't work. The European Data Protection Board has been crystal clear because of the power imbalance between the employer and the employee. Consent in the workplace is rarely considered freely given. It won't hold up. So most organizations rely on legitimate interest. That Article 6(1)(f), but here is the catch. Legitimate interest requires what's called a balancing test. You must document that your business needs for monitoring outweighs the privacy intrusion to your employees. Now, GDPR is the baseline framework, but Article 88 explicitly allows European Union member states to impose additional rules for workplace monitoring. And they absolutely have. In Germany, the Works Constitution Act requires Work Council approval before implementing monitoring systems. Now, GDPR is the baseline framework, but Article 88 explicitly allows European Union member states to impose additional rules for workplace monitoring, and they absolutely have. In Germany, the Works Constitution Act requires Works Council approval before implementing monitoring systems, not consultation. Approval. If your work council says no, you don't deploy. France requires notification to CNIL, their data protection authority, before implementing certain monitoring tools. France requires notification to CNIL, their data protection authority, before implementing certain monitoring tools. Spain's LOP DGDD mandates prior consultation with employee representatives and requires that monitoring policies to be negotiated, not simply announced. This is where the data minimization principle becomes operationally critical. Article 5(1)(c) states you can only collect data that is adequate, relevant, and limited to what's necessary. A financial services company we work with in Amsterdam configured TimeChamp to capture activity levels and application usage, but disabled screenshot functionality entirely for their 85% customer service team. They determined that application level data was sufficient to identify productivity patterns and coaching opportunities without the privacy intrusion of visual surveillance. The data minimization in action. The TimeChamp addresses these requirements with a configurable monitoring intensity, automated data retention limits that align with your documented retention policies, and employee self-service access portals where team members can view their own monitoring data. Satisfying Article 15 request proactively. But here is the reality. GDPR compliance for monitoring is not about the software. It's about your documented justification, your proportionality assessment, and your ability to demonstrate that you have considered less intrusive alternatives. Now, the European Union, represents the restrictive end of the spectrum. But there is another model emerging that takes a completely different approach to workforce privacy. Now, if you are operating globally, here is where things gets really interesting. And by interesting, I mean logically complex. Because While we have covered in the US and the European Union, the reality is that most of the organizations today have distributed teams across multiple continents. And each major market has developed into its own distinct approach to monitoring compliance. Canada operates under PIPEDA, the Personal Information Protection and Electronic Documentation, and its strict PIPEDA requires three critical elements: meaningful consent, clear purpose specifications, and limiting collection to only what necessary to business operations. Let's look about Australia. Australia's Fair Work Act is unambiguous. You can't monitor employee without advance notice. Period. And that monitoring must be quite reasonable in the circumstances, unquote. A legal standard that courts interpret strictly, but there is the complication. State law varies significantly. New South Wales has the Workplace Surveillance Act, which is the most restrictive in the country. It requires written notice at least 14 days before surveillance begins. So imagine you are a global SaaS company with engineering team in Toronto, sales in Sydney, and customer support in Manila, and marketing in London, and finance in Sao Paulo. You need to workforce visibility across all locations. How do you create a monitoring policy that works everywhere? The answer is you build to the most restrictive standard and create tight policies by jurisdiction. You implement transparent notice everywhere. Obtain explicit consent in Canada and Japan. Provide 14 days advance notice in New South Wales. Specify purpose clearly for GDPR and LGBT compliance. And maintain detailed documentation for every jurisdiction. It's complex, yes, but it's manageable with the right framework, which brings us to the next critical question. Beyond legal compliance, what are the critical risks of getting monitoring wrong? Here is where complaints get really sector specific, because certain industries do not just deal with general privacy laws. They face additional monitoring obligations that can actually require surveillance in some cases. Let's start with the financial service, where monitoring is not just allowed, it's increasingly expected by regulators. The SEC and FINRA have made it clear. If you are broker dealer or investor firm or investment firm, you need systems in place to detect insider trading and market manipulations. After the 2008 financial crisis, regulatory securities intensified dramatically. In Europe, MiFID2, the Market Financial Instrument Directive, actually mandates communication surveillance for investment firms. We are talking about monitoring emails, messaging platforms, even phone calls in some cases. A mid-sized investment advisory firm with about 85 employees came to TimeChamp specifically for this reason. They need a detailed activity log showing who accessed what client data, when and for how long. During a FINRA audit, they pulled 6 months of application usage report showing their compliance team oversight activities. The auditor specifically noted the thoroughness of their monitoring documentation. TimeChamp's configurable approach lets you dial in exactly the level of monitoring your industry requires, while excluding what your regulations prohibits. You are not choosing between compliance and visibility. You are achieving both simultaneously. So, we have covered the legal landscape, international laws, US state requirements, and industry specific regulations. Now, the question becomes, how do you actually implement complaint monitoring? What are the practical policies and the procedures that keep you on the right side of all the rules? So, we have covered the legal landscape across the multiple jurisdictions. Now, here is the critical question. How do you actually build a monitoring program that holds up legally, regardless of where you operate? Interesting. The answer comes down to three foundational principles: clear advance notice, documented consent, and ongoing transparency. Get these right, and you transform monitoring from potential legal liability to defensive accountability. Let's start with the notice requirements because this is where most companies fail. Your monitoring policies can't be vague. It needs to specify exactly what technologies you are using, what data you are collecting, how long you will retain it, who has access, and for what business purpose. Generic languages like "we may monitor computer usage" does not cut it anymore. Here is what legally defensible policy language requires. Timestamp software will capture application names and usage duration, website URLs visited, active time versus ideal time, and periodic screenshots during the working hours. Data is retained for 12 months, accessible only to direct managers and HR leadership, and used exclusively for productivity analysis, attendance verification, and project allocation. Notice the specificity. That level of deal satisfies California GDPR's transparency mandates and Australia's privacy principles, all simultaneously. And here is where transparency moves from legal requirement to competitive advantage. Timestamp provides employee-facing dashboards where team members can see their own monitoring data, the same productivity scores, time utilizations, and application usage that their managers see. When a 280% professional services firms in Toronto implemented this self-service transparency feature, something remarkable happened. Formal privacy complaints dropped to zero. Why? Because employees could verify the data themselves. They are not being survived, they are being measured with full visibility into the methodology. Let me give you a real world comparison that illustrates why this matters. Company A with 150% marketing agency implemented Timestamp in 30 days advance notice, mandatory policy acknowledgement sessions with Q&A, and committed to monthly transparency reports showing aggregate productivity insights. 18 months later, zero legal charges, zero formal complaints, 92% employee acceptance rate. Now we'll see about company B. Similar size, similar industry, deploying monitoring covertly, planning to inform employees gradually. Within 4 months, they faced a class action privacy lawsuit and state labor board investigation. The legal cost exceeds $40,000 before they even reached settlements discussion. Have you noticed the difference? Notice, consent, and transparency. Company A invested in compliance upfront. Company B paid exponentially more after. So as we move forward, remember, the technology you choose matters, but how you implement it determines your legal defensibility. Which brings us to our next critical area. Now let's talk about something most organizations completely overlook when they implement monitoring. The data you are collecting about employee is itself subject to privacy and data protection laws. Here is the irony. You implement monitoring tools to improve productivity and ensure compliance. But the monitoring data itself, screenshots, activity logs, time tracking records. This is personal data. In many jurisdictions, it's considered personally identifiable information that triggers the exact same protection requirements as your customer database or the HR records. And here is where it gets tricky. The screenshots intended to verify an employee is working might inadvertently capture sensitive information completely outside your monitoring scope. Customer credit card details visible in the browser window, protected health information in email, confidential financial data from another employee shared screen during the video call. I spoke with a financial service company last year. It's about 200 employees using a competitor monitoring platform. They discovered their screenshots had captured customer payment information during the routine account survey. Suddenly, they had a dual compliance problem: employee privacy concerns under the state law and customer data protection obligations under PCI DSS and state data breach notification laws. Their monitoring system, intended to ensure compliance, had created a compliance violation. So, we have covered the legal landscape, the regulations, the data protection requirements. Now, here is the practical question: how do you actually implement TimeChamp? Are any monitoring platforms with creating a compliance nightmare? Let me walk you through a practical compliance checklist broken into 4 phases: before implementation, during the configuration, at launch, and ongoing. Phase 1: pre implementation. Before you deploy a single agent, you need 3 things. First, a legal review of your monitoring policy, not a template you downloaded from the internet. Actual review by the Employment Council, familiar with every jurisdiction where you have employees. A financial service company we work with has employees in California, New York, Texas, and Germany. Their pre-implementation legal review identified 17 specific configurations required across those 4 locations. Without that review, they would have been non-compliant on day 1. Second, identify application laws by employee location. This is not just country level. In the US, it's state level. In the EU, in the European Union, it can be country specific even with the GDPR framework. Map every employee to their applicable legal requirements. Third, if you operate in an environment with works councils or the unions, consultation is not optional. It's legally required. Now, here is why TimeChamp approach matters for compliance. Unlike surveillance heavy platforms that apply the same invasive monitoring globally and leave you to figure out compliance, TimeChamp is built for configurable, jurisdiction appropriate monitoring. Granular policy controls let you adjust monitoring by location and department or role. Automated data retention ensures you are not keeping data longer than legally permitted. Employee transparency dashboards provide the access right requirement under GDPR and similar laws. Comprehensive audit logs documented every aspect of your monitoring program, and regional data hosting options to keep European Union employee data in the EU, meeting data residency requirements. Now we will discuss when to. Now here is why TimeChamp's approach matters for unlike surveillance heavy platforms that apply the same invasive monitoring globally and leave you to figure out compliance. TimeChamp is built for configurable, jurisdiction appropriate monitoring. Granular policy controls let you adjust monitoring by location and department or role. Automated data retention ensures you are not keeping data longer than legally permitted. Employee transparency dashboards provide the access and its right requirements under GDPR and similar laws. Comprehensive audit logs document every aspect of your monitoring program, and regional data hosting options keep European Union employee data in the EU, meeting data residency requirements. Now, when should you consult a legal counsel beyond the initial implementation? In 4 situations. First one, multi-jurisdiction deployments, union or works council environment, and high-risk monitoring features, termination decisions. In these four cases, we can consult legal counsel. Let me give you the business case for compliance, because I know some of you are thinking this sounds expensive and complicated. First, first penalties. GDPR fines can reach 4% of global annual revenue. California CPPA can fine $16,000 per violation. A single compliance failure can cost more than years of proper legal review. Second, employee trust. Complaint, transparent monitoring maintains trust. Secretive, invasive monitoring destroys it. And the productivity gains you are seeking evaporate when employees feel surveillance survived rather than supported. Third, legal risk reduction. Monitoring data used in the termination decision gets scrutinized in wrongful termination laws. If your monitoring program was not legally compliant, that data may be inadmissible or worse, evidence of improper surveillance. And fourth, data visibility. Monitoring data detection. Monitoring data collected without proper notice and consent may be legally unusable for performance decisions. Scrutiny investigations are compliance audits. You are collecting data you can't actually use. Here is the final positioning. Unlike the surveillance, heavy platforms that maximize data collection and leave compliance as your problem, TimeChamp's configurable approach lets you maintain the workforce usability you need within the legal boundaries appropriate for your industry and locations. You get the productivity insights, the attendance verification, the insider risk visibility, but configured in a way that respects employee privacy, meets legal requirements, and maintain the trust essential for the long-term. Compliance is not barrier to effective monitoring. With the right platform and the right approach, it's entirely achievable. Correct? Are you ready to implement compliant employee monitoring? Please visit timechamp.io to see how TimeChamp's configurable monitoring policies, automated data retention, employee transparency dashboards, and jurisdiction specific controls help you to maintain workforce visibility with legal boundaries. Book a compliance focused demo today and download complete employee monitoring compliance checklist to audit your current monitoring program and against US sales laws, GDPR requirements, and productivity specific regulations. So please go to the timechamp.io website and please book the demo, and it is 100% free. Let's catch up again with another video. This is Praveen Chittuju signing off. Thank you.